The Supreme Court heard arguments Tuesday over whether President Trump's tax return should be released. The president is attempting to shield his financial records from Congress and the Manhattan District Attorney. Last year, the president sued his banks and his accounting firm, demanding they ignore all subpoenas. Justices held a 3-hour session where they questioned both the powers of the presidency and the powers of Congress. Former federal prosecutor and CBSN legal analyst Keir Dougall joins me now. Keir, great to see you. Thanks for being with us. During this hearing, counsel for the New York DA argued that President Trump's financial records are needed for an ongoing criminal investigation. How did New York prosecutors present their case, and how did the justices respond?
Okay, so this stems from the hush money payments that the Michael Cohen, the president's former attorney, testified to and pled guilty to. The New York County District Attorney's Office would have jurisdiction over, entries on the books and records of the Trump organization and perhaps Trump organization affiliates or President Trump's affiliates. False entries on those books about what the purpose of those payments were for could lead to potential criminal liability. You'll recall that when Michael Cohen pled guilty, he identified individual number one as the person directing his actions, and that, of course, was identified as President Trump. So the New York County District Attorney's Office is looking into whether or not there were crimes by Mr. Trump and perhaps others related to the payments, among other things, that might be reflected in those books that were kept here in the state of New York. And the presence of other people played an important role in, or perhaps other defendants or other subjects of the investigation played an important role in the argument. So the president was arguing that the subpoena amounted to harassment and would impair his Article II abilities to act as president. And on the other side, the attorney for the district attorney claimed and argued that, well, everybody's required to give evidence in a criminal investigation and no one is above the law.
So let's talk a little bit more about that. Yeah, President Trump's attorney did argue that investigating and prosecuting the president could interfere with his ability to lead the country. So how did the justices respond to that?
Well, that was a subject of a lengthy part of the argument over the grand jury subpoena, with the district attorney saying that, well, the ordinary rules that govern a grand jury subpoena for relevancy, for instance, would be able to account for the president's perhaps concerns about burdens on the presidency, particularly if those issues were presentable to a federal court. So the argument really turned about who had to make the showing in federal court over a state grand jury subpoena. Would it be that the prosecutors would have to show special needs, a heightened requirement for those documents, and go first, or would the president have to show upon notice of a grand jury subpoena that the burdens were particularly great here, requiring the prosecutors to go second and then explain why they needed them so much? And as this may sound kind of procedural and a little boring, but in the midst of an ongoing criminal investigation, a procedural delay like that could have significant impacts on the investigation itself. And so the order in which the parties had to make their case became important and would be important.
So justices, as I understand it, revisited precedents set by cases against former presidents while they were still in office. How are those factoring into all of this?
So the two prominent cases that were focused on in the argument were the case of Clinton versus Jones and, of course, the Nixon Watergate tapes case. And the Nixon case is probably, it is certainly applicable because it was in connection with a criminal process. What made Nixon different and perhaps required sort of more scrutiny was that The Nixon case related to the president's official conduct, and he was asserting executive privilege. Here, the records predominantly relate to private conduct by the president, and there was no claim of privilege here. In both Nixon and today's case, there were other potential subjects or defendants that have rights. For instance, these other individuals who might have been involved in the hush money payments, the records that the district attorney was seeking, they could be exculpatory. They could be, they could show the innocence of those individuals. They could also show the guilt. But that became a focus of the argument today. In the Clinton case, that was a civil case where the court said, even though there could be thousands of civil plaintiffs who would bring claims, we can deal with that on a case-by-case basis if the president is overly burdened. And in the Clinton case, it was pre-presidential conduct, it was private conduct, and the court said, well, the evidence has got to, the president has got to give evidence just like everybody else, and he's not above the law. So those two Supreme Court cases, which were both unanimous, by the way, are very strong precedents supporting the district attorney's arguments today.
Well, some justices pointed out that former presidents willingly turned over material sought by Congress. How are President Trump's lawyers arguing that this case is different?
So what prior presidents have done is important on the burden question. Given that lots of prior presidents, certainly in the modern presidency, have cooperated and provided their tax returns, among other things, and other personal records, it tends to show that the burdens here, in particular on President Trump, might not be as great as you might fear. So that's, I think, what the point of that particular line of questioning involved is how do you measure the burden on the president, and are the sort of series of perhaps a parade of horribles as described in the court and argued by the president's counsel, are they real, or is it speculative that the president would really be burdened here? Remember, the subpoenas didn't go to President Trump. They went to his accountants and to banks. And so the president himself would not have to physically produce this material.
That's an important point. Finally, Keir, when is the Supreme Court expected to make a ruling?
So this is a very important point. I wouldn't expect a ruling before June. And then the larger question is, well, we've got an election coming up in November, and if these materials are, say, derogatory to the president, is it possible that they would be released to the public in some way? So for the grand jury subpoena for the district attorney's office, those records would be produced to the grand jury, which has secrecy rules. Even if the court were to decide in a few weeks or at the end of June to uphold the subpoena, as the lower courts did, and the records were produced, I think it would be very unlikely that the grand jury materials would become public before the election. For the House subpoena, the court and the lawyers were arguing over whether or not there should be heightened standards. If that were the case, the court could rule that the lower courts have to go back, redo, figure out whether or not a newly announced heightened standard had been met. That would, I think, potentially lead to litigation that could run past the 2020 election. So even if the president were to suffer a legal setback here, he may very well achieve a political victory in causing these materials not to see the light of day before the election.
Right, that election is less than 6 months away now. Keir Dougall for us. Keir, thank you very much.
Thank you, Elaine.